So, welcome everyone to the 2025 Labor Law Update. Today is sponsored by the Workforce Development Board of Ventura County, and we want to thank them for sponsoring today. My name is Anna Manzano. I'm the Digital Media and Event Strategist here at the California Employers Association. Before we officially get into today's training, just a couple details to cover with you. So as you see, your audio is muted for today's presentation, but as you're already doing so in the chat, there's going to be lots of opportunities to engage during today's training. One of the ways you're probably going to be engaging is by asking questions. So the best place to get your questions answered is along the bottom. If you are on a desktop computer, you'll find a button along the bottom that says Q&A. That's the best place to put your question to get it answered, because while one trainer is developing delivering the content, oh my gosh, I am struggling today. Then the other one will be managing that Q&A box, and then they'll switch because sometimes things just get lost in the chat. So we want to make sure that your questions get addressed today. Handouts for this training were sent out in yesterday's reminder email, but I'm going to also drop those into the chat box shortly. So once you see the little icon and file name pop up, you can click it and it'll download locally to your drive. If you have any trouble accessing that PDF, you can just ping me in the chat and I'll be more than happy to figure out how to get it to you one way or another. We always get the question about the recording. So because again, Ventura County is sponsoring today's webinar, after the video processes, I will send the file over to them. And then what they do is once that video is available for playback, they will reach out to everybody with the link to go ahead and view that. So look out for an email from Ventura County. Make sure you're staying on their list and they'll let you know how to review today's recording. Last but not least, we do have a survey. It's 5 questions. It generally takes less than a minute to complete, but towards the end of today's training, you'll see a slide with a QR code pop up. I also will drop a link into the chat. And what the survey does is it really allows us to look at your feedback and hopefully meet and exceed your expectations with trainings like this, as well as our entire suite of resources. And we take the feedback that you share with us, we share it with our partners over at Ventura County, just to make sure that we are serving employers like yourself. So again, our training is brought to you via Ventura County, and I would like to introduce our trainers today. We have Virginia Young, who is our HR Compliance Director, and Eli Nunez, who's one of our HR Directors. And if you have called into the hotline, maybe you've had the pleasure of speaking with either one of them. And I'm going to give it to Eli, who's going to kick us off for today.
Thank you, Anna. Thank you very much. Virginia will be in the Q&A box. So if you have any questions, send them on over on the content. We can answer them as you go along. Once again, I'd like to give a special thanks to the Ventura County Workforce Development Board and remind you that they have this complimentary human resources hotline for you. It's 888-763-3174. You can call it Monday through Friday from 8 a.m. to 5 p.m. with any HR question you have, whether it's anything about hiring, handbooks, policies, lunches, wage and hour, whatever it is, or if you just have an issue that you just want to talk through, give us a call. One of us will answer that phone call from you or get back to you immediately, and we can help you out. We know HR is difficult, so we are there to help. Again, thanks to Ventura County for partnering with us on that number or that hotline. That number is 888-763-3174. A little bit more about us, and if you've been on our webinars before, you've heard this before. We are California Employers Association, and our goal is to help you with the HR part of your business, right? Anybody that calls, anybody we help. We know human resources can be a complicated matter, so our goal is to provide you peace of mind. Do that either through helping through the hotlines or emails with any questions you have, trainings, webinars such as this one, or other resources that we put out. So again, running a business is complicated enough as it is, so let us help you out with the HR side of things. Whether it's questions or news or whatever it is, we can help. Having said that, we do like to give this disclaimer that even though there are people on our team with legal experience, we are not lawyers. CEA is not a law firm, and we do not provide legal advice. So we always advise if you have any questions of a legal nature, please contact legal counsel so they can help you adequately, provide you with attorney-client privilege, that sort of thing. So again, just a reminder, we're not lawyers. Our presentations, our trainings are of an educational nature. We'll talk about some of the laws, some of the requirements, but we do not give legal advice. So with that, let's jump right into our presentation today. And some of the things we'll be talking about in this labor law update, some of the changes you need to be aware of for 2025. So as usual, there's changes in wage and hour, So whether it's increasing wages or it's changes to PAGA or or protections for independent contractors, we're going to talk about employee rights. Some of the changes, some more protections for employees that came about. Then I will hand it over to Virginia and she'll discuss changes to employee leaves of absence and benefits, as well as things to be aware of for safety in the workplace. So we'll jump right into it for with wage and hour, which we know, again, there's been changes. It seems like every year, as in the past few years, and 2025 is no different. Once again, minimum wage has increased this year. It's gone up from $16 to $16.50 effective January 1st of this year, and that applies to all employers. If you remember a few years back, there used to be like a tiered system where smaller employers had a lower minimum wage as opposed to larger employers. That's no longer the case now. All employers across California have a minimum wage of $16.50. And this is important to keep in mind too, because this also affects your exempt employees. So if you have any, say, managers or supervisors that are exempt, that are on the salary basis and not and exempt from overtime or meal break protections, their minimum wage has gone up as well to $68,640 per year. And the way the state comes across that number is they take the hourly minimum wage, multiply it by 2,080 hours, which is the equivalent of a 40-hour work week for the whole year, and then they double it, coming up with $68,640. So if you find yourself in a situation where you're not paying your exempt employees that much, or you can't really, budget that much of a raise, then you may consider transitioning back to non-exempt employees. There is such a thing as non-exempt managers and non-exempt supervisors. And keep in mind that in the state of California, all employees actually default to non-exempt hourly employees. So it's an easier transition, at least on paper, because as you know, I mean, sometimes employees see going from an exempt salaried type scenario to a non-exempt hourly scenario as a demotion, because they have to go back, they have to clock in and out, they have to take their meal breaks on time, they have to take their regular breaks, et cetera, et cetera. So if you find yourself in a position where you need to transition an employee from a salaried exempt position to an hourly non-exempt position, we do have some tips and advice on how to do that. You see that bit.ly link there on the screen. You could type that into your browser and it'll give you some guidance, some ideas on how to manage that situation, which could be, a little awkward, a little difficult. Something else to keep in mind with the minimum wage too is that while the state gives us the minimum across the board, that's $16.50, there are some municipalities that have a higher minimum wage throughout the state. And I'm looking at, some metropolitan areas, whether it's, near Los Angeles, LA County, up in Northern California, it's the Bay Area, Emeryville, Oakland, San Francisco, that sort of thing. That hourly minimum wage can be a little bit higher. Now, that hourly minimum wage, that local hourly minimum wage, if it's higher than the state one, doesn't have any bearing on the salaried exempt minimum wage. But it's still important to keep in mind if you have employees that are either working remotely and live in these areas, or if you have a workforce that travels to these areas to perform work. And I'm thinking of jobs like handyman, um, construction, landscaping comes to mind where they travel to different cities. You have to be aware of what that local minimum wage is to make sure that you are paying your employees correctly. Something else that comes into play too is that paid sick leave, predictive scheduling, or flex time requirements may be different in these different cities. So you have to be aware of that and make sure that those protections apply to those employees that either live and work there or are traveling there to perform any work. And again, if you have remote employees, that local minimum wage is based on where the employee's physically working. So if they're working from home, if they have a home office, that minimum wage protection is going to be the one that applies. So we do also have a spreadsheet, a bit.ly with those changes so you could keep up with those. Again, and usually there's increases at the beginning of the year and for these local minimum wages, but be aware that a lot of them also increase their minimum wage halfway through the year. So July 1st, we see a lot of increases pop up throughout the state in these places. Every once in a while, somebody will do it a little bit earlier. I believe last year, San Mateo County up here in Northern California did it right around April or May instead of waiting until June. So just kind of keep an eye on it. Keep an eye on our blog. We'll let you know if any of those changes come up, or you just be aware that some of these municipalities do have different requirements. Now, on the more industry specific topic, a lot of news was made about the fast food minimum wage that came into effect on April 1st last year. Minimum wage for limited service restaurants that or chains with over 60 locations across the nation have gone up to $20 an hour. And that came into effect on April 1st, 2024. Um, the state also gave us some clarification that that minimum wage does affect exempt employees in those locations or those industries. So if you are part of a franchise and you have exempt employees, then those exempt employees have a minimum wage of $83,200 per year for those in that fast food industry. So again, there's another one of those situations where it may make sense to transition those exempt employees to an hourly status, um, because that is quite a steep jump, especially going from the state salary minimum wage to that fast food salary minimum wage. Now, there was no increase as of January 1st to the fast food minimum wage, but the Fast Food Council does have the ability to recommend or make recommendations on wages and working conditions. So keep an eye on them as well, in case there is any kind of increase throughout the year or in the middle of the year, like any of the other municipalities tend to do. Healthcare minimum wage also came into effect October 16th of last year. And this is one that had been tossed around a little bit. It was supposed to come into place earlier in the year, but it was delayed due to the financial situation of the state until it finally came into effect on October 16th, 2024. And this one's possibly a little more complicated than the fast food one because there's different tiers depending on the size of the organization and whether they're part of a larger group or that sort of thing. So this is one where if you think it applies to you, it's a good idea to give us a call on that hotline and we could talk through it to see what the requirements are for that one. Now, the goal for the healthcare minimum wage was to get healthcare employees up to $25 an hour eventually, and that's going to be a tiered approach, right? They're not going to do it all at once. It's going to be gradual increases to get to that point. Um, Right now, the range is from $18 an hour to $23 an hour, again, depending on the size of the employer and where they fall into the hierarchy in the state. So keep an eye on that or take a look to see which one applies to you. And this is another situation where the exempt employee salary is also subject to slightly different rules than the state one. So in this case, if you are in one of these locations that is affected by this healthcare minimum wage, in order to qualify for an exempt employee or an employee, they must be paid at least either 2 times California's minimum wage or 1.5 times the healthcare minimum wage that applies to you, whichever is greater. So a little bit more math to be done to figure this one out. But again, first thing to do is take a look to see if this applies to you, what tier you fall under, and then you start figuring out what you need to pay your exempt employees to keep their exemption compliant with state law. All right, something a little bit less complicated and that we've seen year after year is an increase in mileage reimbursement for employees that use their personal vehicles for work. And it seems every year the IRS releases what the mileage rate will be for the upcoming year. And for 2025, it increased 3 cents per mile up to 70 cents a mile. Now, this 70 cents per mile is meant to cover fuel, wear and tear, insurance, basically the use of the vehicle itself. If you have hourly employees that drive for you or that are driving as part of their duties for you, you still have to pay them the hourly wages in addition to the mileage reimbursement. So that 70 cents per mile does not cover the employee wages or the employee compensation. That only covers the use of the vehicle itself. We recommend always going with the IRS rate because that is obviously very defensible. That's what the federal government has decided is what's appropriate for reimbursement for personal vehicle usage. And the other thing is that if you decide to go with anything lower than that 70 cents, then it is up to you to prove why it is appropriate. So whether you have a separate stipend besides the mileage or whatever it is, it's up to you and your payroll or accounting department to prove that that is enough to cover the expense of the vehicle usage. So again, the easiest thing, honestly, is just use that 70 cents per mile. But if you really feel that in reality your business's expense should be lower. Just be ready to defend that decision. Some big news that came this year too, and this became effective July 1st of last year, was a reform to PAGA. That's PAGA is the Paid Attorney General Act. Um, so this reform came about because of there was a move basically to eliminate PAGA. There was some talk about just getting rid of PAGA altogether. And as a business owner, if you've been around California for a bit, you know that those are that name or the word PAGA tends to make that hair in the back of your neck stand up a little bit, right? I mean, it could definitely be very expensive and sometimes even devastating to a business if they have to defend a PAGA claim. So again, this instead of eliminating PAGA altogether, there was a deal struck between the legislature and business groups that gave businesses a little bit more of a defense or a little bit more teeth to fight against some of these PAGA claims. We'll talk about what these are here in a minute. Now these new guidelines or these new defenses basically apply for any cases filed on or after June 19th of 2024. So it's not retroactive to existing cases, but just for anything filed from June 19th going forward. So, if anything, I mean, it's some good news is better than no good news at all. And that's what we're seeing here. So really, what this does, this new act is just basically gives employers an opportunity to basically mitigate some of the damages of these PAGA lawsuits, right? So basically what this does is it lets employers, sorry, um, reduce their penalties a little bit by showing that they are doing things to comply with wage and hour laws. So some of these things can include, auditing their payroll, auditing their files, basically taking action whenever they find a mistake. Having written policies that abide to all state laws and state regulations, uh, having documented training for their supervisors, right? As an employer, you know that your supervisors, the ones that work with your workers day to day, they're the ones that sometimes make those decisions that either keep you prosperous and keep you afloat, or if they make a mistake and pass that information on to your employees, that can have really bad repercussions for you. So again, having that training for the supervisors on wage and hour and employee protections is very important, as well as taking corrective action on any supervisors that are not following your policy. So as you've heard from our webinars before, documentation is so important. So being able to document that you have those written policies, that you've provided that training, and that you're issuing corrective action to fix any issues is going to help you down the road. And if you need any help, we do have a wage and hour package available for wage and hour audit package, I should say, for you to use to audit your payroll or your wage and hour files in order to help identify any issues and help you with any kind of try to mitigate any kind of PAGA issues coming up. Something else that we had come about was Senate Bill 988, which is the Independent Contractor, the Freelance Worker Protection Act. So this Senate Bill 988 basically applies to any freelance worker that provides professional services as an independent contractor. This is not an employee, this is for independent contractors, right? Now this bill has no effect on the independent contractor versus employee test, the ABC test we see in the state of California, but it basically offers more protections for those basically one-man teams, right? Those freelance workers. So it kind of extends the protections that were already available for independent contractors over to them. So some of the requirements or the new requirements are there has to be a written contract whenever you engage a freelance worker to perform work for you. And that should include things like the name and mailing address of each party, the list of services, compensation, dates of service, that sort of thing. So we have to have it in writing now. No more handshake deals or writing out on a cocktail napkin, basically. And it also has protections against changing the scope of work or the compensation in the contract or what that was agreed upon once the work has started, as well as retaliation protections for these freelance workers. Now, some of the services covered under this act would be things, on this list, and we'll go through all of them, things like marketing, photographers, writers, performing teachers, teaching master classes, estheticians, that sort of thing, right? So take a look at that list, and if you are, bringing on any freelance workers or independent contractors to perform these services for you, make sure that you're staying compliant with the protections, have a written contract, and basically you're following what that contract says. Now, some to-dos for you for wage and hours. Make sure that you're paying the correct minimum wage, obviously, whether it's a different municipality or just a state one, whichever one applies to you, and that when you do make those changes, you do them in writing and update those wage theft notices, right? Um, just basically document any payroll change for non-exempt employees, no matter what. Um, Look at your salaried employees, make sure that salary exempt employees, make sure that they're making enough money to maintain that exemption. And then, take a look at to see what you can do, what reasonable steps you can take to help correct and identify any issues, that can help you down the road in case there's ever any kind of PAGA claim to help with those PAGA reform protections. And finally, if you do contract any freelance workers or independent contractors, take a look at the requirements to make sure that you are abiding by all of them. Now I'll take a look at some protections or employee rights and protections, some changes that came about this year. And the first one is some changes, and these are from the federal government. The Equal Employment Opportunity Commission gave us some or updated their harassment guidance. And this is after 25 years, and they finally made some changes to it. Basically, it's kind of catching up to California, if you will, right? As we know, California has a lot of protections, a lot of guidelines for harassment. So the EEOC basically gave 77 new examples of what can constitute harassment. These could be things like intrusive questions about someone's sexual orientation, gender transition, or intimate body parts, denying access to a person to the bathroom for a person based on their gender identity. And again, also talked about how harassment can occur in remote work environments. Very important to keep in mind since we've had this massive shift to remote or hybrid work in the past few years. So again, harassment does not just occur in person. We have to be careful what goes on in webinars or online meetings or phone calls or that sort of thing. And it also defined or introduced this topic of intersectional harassment. And this basically stated harassment can be based on more than one protected characteristic of an employee. So, we'll give an example about this in a bit, but basically it states that harassment can be based on, say, race and age at the same time. Now, FIHA's has already had this definition or this concept of intersectionality defined in it, and there's the California agency, and basically it just states that you can discriminate unlawfully or harass somebody not just be on one protected class, but a combination of two classes or more. So, for instance, if you are harassing, say, an older woman that's a coworker, and you're telling, she mentions you forget something, you say, oh, well, that happens a lot. You must be going through menopause, right? At that point, you are basically making an assumption, making, an incorrect statement or making an offensive statement based on their gender and based on their age. So that's kind of exemplifies what intersectionality means. You're committing harassment based on more than one protected class at this point. And again, this Senate Bill 1137 that came about kind of mirrors the guidance that the EEOC put out to basically flesh out that definition of intersectionality and how it applies. So it's very important to take a look at your harassment policies, make sure that you have those concepts in there, and as well as possibly some examples of what they are. SB 1100 also came into play this year, and this one relates to driver's license discrimination. Now, what this law says is that we can't require a driver's license from applicants either in their advertising posting or application unless, and there's two exceptions to this, you expect driving to be a function of the position, and you believe that alternate transportation would not be comparable in travel time or cost. So for example, us here at CEA, we travel on site to do trainings and other services for our members. So in those cases, it is reasonable to believe that a driver's license is necessary because for us to take an Uber, to take public transportation from where we are here in Sacramento to places like the Bay Area or Fresno or Bakersfield is not really realistic or comparable in time or cost. So take a look at your job postings and your job applications. If you do have a requirement for a driver's license, make sure that it is truly a necessity of the job, right? Don't just throw it on there just because it's always been on there, but make sure that if you're requiring a driver's license, it is because driving, your own vehicle or whatever it is an essential part of the job. Next one we have is Senate Bill 399 or SB 399, and this relates to captive audience meetings. Now, what this law states is that employees can decline to attend any meetings their employer gives where their employer is giving their opinions on political or religious matters. So, for instance, if your employer calls a meeting to discuss to you why they don't think you should join the union or who you should vote for or how you should vote on an upcoming election, employees have a right to decline attending those meetings. And there cannot be any adverse action against them. On top of that, if there is one of those types of meetings and an employee declines to go, they still need to be compensated for the time that they would have been paid to go to the meeting. This kind of lines up with the NLRA or the NLRB, sorry, rules that captive audience meetings aren't permitted. But as you would expect, as soon as this law came out, there's already been some legal challenges to it, basically claiming that it goes against the employer's freedom of speech. So keep an eye on this one. We'll see where these challenges go. But for the time being, captive audience meetings are not allowed in the state of California, or if you do have them, your employee can decline to attend and must be compensated for that time as well. Finally, some changes to labor law posters, and hopefully, you update those posters every year, get those orders in November, December, and then put them up in January. So we do have a couple different ones that were updated. First one is AB 2299, the whistleblower protection poster. Basically, they changed some of the language in it, so make sure you have the newest one. Minimum wage posting, of course, as the minimum wage changed, make sure that you have the newest one up there, along with any supplemental posters if necessary for fast food and healthcare industries. Assembly Bill or AB 1870, that is the workers' compensation rights bill that has been updated as well to include language regarding employees' right to consult an attorney, the attorneys and the attorney's fees as well. And finally, the Civil Rights Department has new discrimination and harassment posters, as well as family care and pregnancy disability leave posters. So make sure you have the newest one. If you order those all-in-one posters from us here at employers.org, they will have all the most up-to-date posters on there as well. So again, make sure that you're changing those every year, or if you do it yourself, make sure you're keeping up with the changes. So some to-dos here for employee rights. Make sure you stay up to date on harassment prevention training. Again, that's a 2-year cycle, so make sure you're on the cycle. Make sure you're training your new hires or employees that have just been promoted to a management position. Uh, you know, we recommend immediately make it part of your orientation. Train within those first 30 days to make sure that you stay compliant with their training. Take a look at handbook policies, especially regarding protected classes. Make sure those are up to date. Take a look at your postings and applications. Make sure that those all comply with new laws. And again, train your supervisors. Train them on wage and hour, but especially train them on this captive audience meeting laws. If your supervisors are having impromptu meetings to discuss political issues or religious issues or, to talk about, unions pro or con or whatever, make sure that they know about employee rights on those. So talk to your supervisors, make sure they are trained and up to date on that. And finally, get those labor law posters either posted if you already received them or get them ordered if you haven't done so. Now, if you ordered them back in December of last year and haven't received them yet, don't fret. If you have any kind of visit from a state agency before you get that poster, just show them proof that it's already been ordered, show them your receipt, and that should help hold them off until you receive that poster. So that brings us to the halfway point here. I will stop sharing and get ready to hand it off to Virginia. But first we'll see if we have any any questions pending out there, anything floating out there that we need to address. Question that just popped up, I saw it on there. Captive audience, is that for exempt and non-exempt? That is for the way we read it. That is for all your employees. So again, your employees can decline to attend those meetings if you're going to be sharing your beliefs, thoughts, or you know um, advice on politics, religion, unions, that sort of thing. So again, recommend that you extend those protections to all your employees. So I will let Virginia pop on here and see what the second half has in store for us. And just a reminder too, if you pre-order your posters, if you see on the chat, they did ship out on Monday, so keep an eye on the mail for them. Again, just have that proof that you ordered them already, and make sure that you're there. Question did just come up on the chat. I will address that directly here in a sec if you give me just a moment. All right, so another reminder too, if you are a CEA member, I talked about harassment prevention training, you also have the opportunity to access that harassment prevention training on our CEA University online. So make sure you're making the most of that service. But if you're looking for any kind of in-person training or anything, just reach out to us and we can give you your options there as well, or you can take a look at the website. All right. So with that, let me see what questions have popped up here.
Sorry, having a quick problem sharing my screen.
No worries.
Just
No
one
worries.
moment. Thanks for bearing with me.
Yeah. The question that came up was if you have an employee that drives any kind of, say, like an industrial machine for you, if they have like say for example a forklift driver, can you require a driver's license? If I'm not mistaken, having a driver's license is not a requirement for driving a forklift on your property. So I don't believe that is something that you would be able to require. Although you can require them to go through your specific forklift training program. So make sure that you have a solid program there so they can go through that. Did you want me to bring it up, Virginia, and I'll drive for you?
Thanks. Yeah, that
Yeah.
would help. I
Okay.
appreciate it. Sorry for the technical
No
difficulty there.
worries. Let me do this here.
While they're getting set up, if you guys have not been following along, I've been trying to keep up with our presenters on dropping links into the chat to make it easier for you guys to click through on those bit.lys, because I know the screen is not clickable. So trying to put those in the chat for you. So make sure to open those up in a browser window so that you have those resources available for after today. But the links will be in your PDF handout of the slide that you can then copy into your browser window.
All right, I'll be in the background.
Okay, thanks, Eli. Thank you for your patience with my technical difficulties here. So let's get started about some new laws in 2025 relating to employee leaves and benefits. The first law that employers should be aware of is AB 2499, which is an expansion of California laws that protect employees who are victims of crime. There are two main requirements, just as a refresher of what these laws require before we get into the changes. These laws require all employers to provide time off from work on an unpaid basis for employees who are victims of certain crimes who want to seek relief in court for their own safety or the safety of their child. This is things like temporary restraining orders and other injunctive relief from the court. The other requirement of these laws is for employers to provide reasonable accommodations for employees who are victims of certain crimes to ensure the employee's safety at work. And this can include a number of things, such as changing the employee's schedule or perhaps their work location or their workstation, changing the phone number, providing information about victim assistance programs to the employees, a whole array of things. So if an employee is a crime victim of a serious crime, such as domestic violence, sexual assault, or stalking, employers do have this duty to provide a reasonable accommodations for the employee's safety. And with these requirements comes the requirement of employers to maintain employee confidentiality relating to these protections. So we could go to the next slide. Eli, if you don't mind. Thank you. So prior to, so 2025, AB 2499 sees some changes to these requirements for all employers. First, there's a new definition of a victim, which will broaden the kinds of things that can make an employee eligible for these protections. We'll go over that on the next slide. The other main change for all employers is that the reasonable accommodation requirement that I was just talking about now applies when either the employee is the crime victim or when the employee's family member is the crime victim. And there is a specific definition of a family member, which we will also look at on the next slide. So, a couple of other things that are important for all employers of all sizes. Employees can use their paid sick leave for all of these crime victim purposes when they're off work. And this is important because you will need to calendar this new requirement. There is going to be a new crime victim notice that all employers are required to give employees. They have to give it when a new employee is hired, when an employee requests leave, or when the employee notifies the employer that they or a family member is a crime victim. But what is new and a little bit unusual is that this notice has to be given to all employees on an annual basis, whether or not the employee has expressed any need or interest in this leave or other reasonable accommodation protection. So it's something to calendar. There will be a new notice issued by the California Civil Rights Department by July 1st, 2025. You do not have a duty to provide notice until the agency comes out with their official notice, but you do need to be prepared for these ongoing notice requirements once that notice is posted. And at CEA, we're definitely keeping an eye out on the agency website for that notice. Next slide, please. So I talked about some new definitions of victims and family members. A victim under prior law, the definition of a victim was tied to domestic violence, stalking, sexual assault, crimes causing physical injury or death of a family member. Now the definition of a victim is broader. It's any individual against whom a qualifying act of violence has been committed. And that does include the things that it included before, domestic violence, sexual assault, and stalking, but it also generally includes conduct or patterns of conduct that include a bodily injury, death to another individual, use or threatening use of a firearm or other dangerous weapon, or threats to use force to cause physical injury or death. So it's a pretty broad definition. There will be more kinds of crimes that will qualify employees for these protections. A family member is the other new definition that you need to be aware of in connection with the crime victim laws. It's defined the same way as in the California Family Rights Act and includes child, parent, and grandparent types of relationships, as well as siblings, spouses, and domestic partners. It also includes the designated person, which you're probably familiar with under the sick leave laws, as well as under CFRA. For purposes of the crime victim leave, a designated person can be any individual related to the employee by blood or whose association with the employee is the equivalent of a family relationship. And like with sick leave and with CFRA, an employer can limit the employee to one designated person per 12-month period. So next slide, please. So for small employers, the main changes are to look out for this new notice requirement, to be aware of the new definitions of and an obligation to provide reasonable accommodation when a family member is a victim. If you have 25 or more employees, you have always had more time off from work requirements than smaller employers under the crime victim laws. But with AB 2499, there will be even more reasons employees can take time off from work. And those are listed here on the slide, in addition to medical attention and victim services for themselves. They will be allowed to take time off for these services when the family member is the victim. Same with safety planning and relocation reasons. Either the employee or the family member can be the victim. And leave can also be available for employees to find a new school for a child, to provide care to the family member who's a victim, or to provide child care or dependent adult care to ensure safety. So more reasons that employees can take leave for larger employers. The victim of the crime can be the family member, is another key point. There are some clarifications that the law made, which are helpful to employers administering these laws. Employers can now expressly limit the total combined leave to 12 weeks. And it is clear that if the leave is being taken for a reason that qualifies under CFRA or FMLA, such as the employee's serious health condition or caring for a family member, that leave under this crime victim law can run at the same time as the employee's 12-week FMLA or CFRA requirement. There is an additional opportunity, maybe that's not the right word, additional way for employers to limit leave under this new law if the family member is the victim, and unless the family member is deceased as a result of the crime, the employer can limit leave to 10 days total or 5 days when used for relocation or school change purposes. So on the next slide, a couple of just reminders, which actually it's not the next slide. We'll get to that at the end. Just be aware of the new notice requirements. You will need to update your handbooks and be aware of this new posting. So now we can move on to paid family leave changes, which are another change for 2025 that employers need to be aware of. As a quick reminder, paid family leave is a state-run program by the Employment Development Department, similar to SDI, but under the paid family leave program, employees can receive wage replacement benefits when they are missing work to care for a family member with a serious health condition, or to bond with a new child, or in some circumstances relating to a family member's military service, qualifying exigencies due to military service. Under the old rule, employers could require employees to use up to 2 weeks of their accrued vacation or PTO prior to receiving these benefits from the state. However, beginning January 1 of 2025, employers can no longer require employees to use this time off. Instead, employees can choose to receive their paid family leave benefits immediately. So if you have a paid family leave policy in your handbook, it may very well have a requirement that employees use their vacation before receiving benefits. That will need to be updated, as will your leave policies and forms. And what's also really important is to train your payroll staff or anyone who may be talking to employees or administering their leaves of absence. So that's it for paid family leave. The next leave and benefit change that we should be aware of is the requirement to register for CalSavers. This has been going on for a number of years. As a reminder, CalSavers is a retirement savings program that the state of California runs for employees. And employers who do not have a retirement plan at work are required to register with CalSavers. And their employees then have the option to participate in the state-run retirement savings program, in which case the employer will have to facilitate that by taking payroll deductions and remitting those to the state. So the CalSavers program is run by the state, but employers do have a role if their employees wish to participate by taking these payroll deductions and making sure their payroll rosters are updated with the state so that new employees can be given the option to participate. There have been a series of rolling deadlines for employers who are not exempt to register for CalSavers, and 2025 is the last year of these rolling deadlines, because by the end of 2025, employers with just one or more employees who are not exempt from CalSavers will need to register by the end of the year. So if you haven't done that yet, made a determination that you're exempt or registered, that needs to be done this year. So I think to wrap up our leave and benefit to-dos, I mentioned updating the crime victim policies and other affected policies such as paid sick leave. And look out for that new crime victim notice by the summer, by July 1st. Make sure you update your leave practices so that you're administering your paid family leaves as required by law, the new law, and not requiring use of vacation. And register for CalSavers if you haven't done so. If you need assistance with this, with updating your handbook, please reach out to us. We can provide help in all of these areas. And with that, I know we're short on time here, so we will next move to health and safety updates for 2025. We're going to talk about some new health and safety requirements that actually took effect during 2024 in July. And those are the Workplace Violence Prevention Program and the Indoor Heat Illness Standard. So we'll talk first about the workplace violence. The workplace violence requirement, many of you are already aware of it because you were required to have a workplace violence prevention program by July 1st of 2024. But if you've done your program, that's fantastic. But if you haven't, that's something to start working on or get in place now. But for everybody, it's important to know that there are continuing obligations under the Workplace Violence Prevention Standard. Your plan has to be updated every year, and you have to train your employees every year on your Workplace Violence Prevention Program. So again, the Workplace Violence Standard applies to almost all employers with very, very few exceptions, one of which is employers who have been covered by the healthcare industry workplace violence standard. That has been in place for many years. So if you're covered by that already, by virtue of being a healthcare employer, then this standard does not apply to you, but it does apply to almost everybody else. So what do you need to put on your calendar for next year once you get your plan in place? You need to make sure you're doing periodic hazard inspections during the year, and having periodic safety meetings is highly recommended. This is important because by the end of the year, you need to solicit employee feedback about your plan, review your workplace violence prevention program, update it, and train your employees on it. So all of those things need to be part of your calendar for continuous maintenance of your workplace violence prevention program. This sounds overwhelming. We do have comprehensive assistance with setting up and maintaining your workplace violence prevention program with our do-it-yourself workplace violence prevention package, which is available at the bit.ly link on the website. And I think Anna's sending it around in the chat as well. So that is the first health and safety standard that went into effect in 2024 that employers need to know about. The second is the indoor heat illness standard. And you may be aware that employers, outdoor places of employment, have been required to have heat illness prevention plans for many years. Finally, in July of 2024, there is a new indoor heat illness standard that applies to employers who are not outdoor places of employment. So if you have 4 walls and a ceiling, you are that is an indoor place of employment. And when your indoor place of employment, when temperatures reach 82 degrees or above while employees are present, this indoor heat standard applies to you. This is not an industry specific standard. So, you need to think about all indoor places that are not air conditioned basically could be subject to this standard. Restaurant kitchens, sheds, food trucks, it's not limited in that regard. So it's the temperature and not the industry that is going to drive your coverage under this standard. What do you need to do? Well, you need to have a written heat illness prevention plan for your indoor employees. It needs to cover, and you need to have in place, available water to employees. It needs to be available at all times. It needs to be free. If you're providing bottled water, you have to have enough to provide each employee with a quart of water for every hour that they are on duty. You need to have cool down areas that are shaded from the sun and allow employees to take breaks to cool down as needed. You do need to train your supervisors to recognize heat illness and employees to recognize the symptoms of heat illness and the dangers of it. And you do have to have your emergency response procedures in place. Another thing you need to train employees on and have be part of your plan is to acclimate employees to increased temperatures when there is a heat wave, meaning when the temperature is more than 10 degrees above average for more than 5 days in a row, over 80 degrees. Supervisors need to be trained on how to allow employees to acclimate slowly to these increased temperatures during a heat wave. And if you have high heat issues, meaning when the temperature or heat index exceeds 87 degrees, or when it exceeds 82 degrees, but your employees are wearing very restrictive clothing or near a heat radiant source. And for restrictive clothing, we're talking about something that covers you from head to toe, is waterproof, something that employees would wear, to be protected from chemicals. That's also going to keep them very hot. So the lower temperature in those situations would trigger the high heat requirements. And what those are first of all, you have to record the heat temperature and heat index. You have to watch it carefully when that is an issue that affects your workplace, the high heat thresholds. You have to provide monitoring for new employees to make sure that they are adjusting to the high heat. And you have to consider both engineering and administrative controls of your workplace. Engineering means, measures to make it cooler, and administrative means scheduling so that employees aren't necessarily in the heat as long. So if you are an indoor place of employment that might have temperatures above 82 degrees when employees are present, then you should prepare for the application and have your plan in place to protect employees from indoor heat illness. I while we have welcomed 2 new health and safety standards this year, we are saying goodbye to one. COVID-19 non-emergency standards, which have been in effect, I believe, since 2022, are going to sunset on February 3rd of 2025. However, it's not completely over because certain record keeping requirements will continue until February 3rd, 2026. So we can encourage you to continue compliance and monitoring of Cal OSHA's website for any changes, because as we all know, things can change, and COVID is still circulating. So it's important to keep aware of any changes that come up. And that bit.ly link at the bottom of the slide is a good one to keep abreast of new developments in that area. So that is it for health and safety. Just remember there are 2 potential written plans that you might need for safety. These can either be part of your illness and injury prevention plan or standalone. That's your workplace violence prevention and your indoor heat illness prevention. And then to monitor your COVID-19 requirements to the extent any come up after the February 3rd sunset. CEA does have safety partners, Safety Center, Safety Compliance Company, and Shaw Law Group, who are available to assist you with your additional safety needs. And with that, I will go talk about what is next for California employers. As we've mentioned throughout this presentation, it's important to stay abreast of new laws. It's also important to stay up to date on your trainings. Remember that mandatory harassment training has to be completed every 2 years, workplace violence prevention training every year. And it's important to take advantage of all of the PAGA reforms that Eli was talking about earlier in this presentation by making sure that you are training your supervisors on wage and hour requirements and best practices. Keeping your handbook current to reflect new laws and developments is also important, and CEA can assist you with that. We have a number of options on our website that you can look into. Make sure you have your new minimum wages and have paid attention to local ordinances requiring higher than the state minimum wage. Make sure you have your updated posters, and please stay tuned to CEA for further developments throughout the year by following our blog. So with that, I will turn it back to Anna, I think, unless we have some questions that need to be answered.
No questions. The only thing that came up, there were a couple on CalSavers. So for employer resources, you can go to employer.calsavers.com. And so to turn it over to Anna, I will add that website to the chat so you guys can take a look at that. If you have any questions, it also shows you how to register if you need to submit your rosters and that sort of thing. So Anna, take us home.
Perfect. If we could get me to the next slide, then I can speak to CEA membership. So I know that this, again, this webinar is very gratefully sponsored by our team over at Ventura County. But if you would like more resources beyond what is presented, we would love to partner with you. So if you head over to employers.org, that first link you'll see along the header is membership, and we would love to connect with you about how we may be able to serve you in 2025 and beyond. And I think next we've got HR Assist is another way that we're able to partner with you. It's kind of like having an HR team in your back pocket. We've got an amazing team that is just able to work with so many companies and just provide them with a lot more peace of mind. So this is something that is also available to our members. And then I think the next one, again, we want to thank the team over at Ventura County, Cynthia, Colleen, Rebecca, the entire team there for sponsoring webinars like this today and for providing employers like yourselves with the entire suite of resources. So please make sure you take note of that HR hotline. It's available Monday through Friday from 8 a.m. to 5 p.m. We will be off for the Monday holiday. However, we really look forward to connecting with you through the end of this week and then again on Tuesday morning. And you can also reach us ceainfo@employers.org. As we moved on to the next slide, I do want to also speak to, I dropped in the chat a minute ago, the next training coming up sponsored by Ventura is going to be be February 11th. Leave laws in California. So we did touch on it a little bit. Virginia and Eli did an amazing job speaking to it. However, we will devote the entire 60 minutes to leave laws. So we'll really go deeper. We'll talk about additional leave laws. So we really encourage you to take advantage of that resource available to you. Now back to the slide. So as I mentioned at the beginning, we will have a quick survey, and that is 5 questions. It's less than a minute to complete. So we really appreciate you sharing your feedback with us today. And if you are joining us for continuing education credits, I'm dropping those into the chat right now, and I will read those out to you. HRCI code 690597, 690597. I feel like I'm playing bingo. SHRM code 25-7T as in Tom, P as in Peter, SW 25. Thank you for a little laugh there. 25-7TPSW. If you have any questions about redeeming those codes, what do I do with these? What do they mean? Please reach out to us, ceainfo@employers.org, or just reply to the reminder email that I sent you yesterday. I'm more than happy to guide you as to where to put those codes to make sure that you get credit for today. And with that, we made it, my friends, only 2 minutes over. Thank you for joining us for today and joining us live. Again, we want to thank the Ventura County team for putting on today. We want to thank Virginia and Eli for sharing your energy and your time and expertise with us, and for rolling with us through some technical difficulties. And we did it.